We shall commence this module by studying about the Companies Act 2013 broad features. In general, company means an association of persons for a common object. The term company is derived from the Latin word com, means with or together. Panis means bread and originally referred to an association of persons who take their meals together. Company as a form of business is traditionally called joint stock company. By a company is meant an association of many persons who contribute money or money's worth to a common stock and employ it for a common purpose. The common stock so contributed is denoted in money and is capital of the company. The persons who contribute it or to whom it belongs are members. The proportion of capital which each member is entitled is his share. Shares are always transferable, although right to transfer them is often more or less restricted. However, joint contribution of capital is not sufficient to describe a company. In partnership firms also, the capital is brought jointly by the partners. Company different from partnership firms is not merely an association of persons. It is an incorporated association of persons created by law to carry on the expressly laid down objects. A company exists only in the contemplation of law. Law creates it and law alone can dissolve it. It may be formed by an act of parliament or by royal charter or by registration under company law. The essential feature of company is that it is an incorporated association created by the law. Chief Justice Marshall of USA has defined a company as a person, artificial, invisible, intangible and existing only in the eyes of the law. Being a mere creature of law, it possesses only those properties which the charter of its creation confers upon it, either expressly or as incidental to its very existence. Company as a form of doing business has its origin in 1600 AD, when the East India Company was established by way of a royal charter in England. Subsequently, the legislative developments in the mid-19th century in the UK gave rise to the modern form of company. At present, company has become a predominant form of doing the business. This is on account of numerous advantages which a company has. Corporate laws world over have regulations regarding formation and functioning of companies. In India, the Companies Act of 2013, known as the Indian Companies Act 2013, contains the law relating to companies. The Companies Act, being the act of the central legislature, that is Parliament, applies to companies throughout India on a uniform basis. After studying this module, you shall be able to know the meaning of company, learn the broad features of the Companies Act 2013, understand how the Companies Act is implemented. Let us now discuss about the Indian Companies Act 2013. The Companies Act 2013 was passed to consolidate and amend the law relating to companies. The Act comprises of 7 schedules, 29 chapters and 470 sections. The Act extends to the whole of India. The Act of Parliament received the assent of the President on the 29th August 2013. The Act shall be applicable from financial year 2014-2015. Objectives. As per the results, Framework Document RFT, Ministry of Corporate Affairs 2013-2014, objectives of the Companies Act 2013 are as follows. First, to provide simplified laws governing corporate sector and to facilitate effective compliances and enlightened regulatory regime. Second, online delivery of all registry related services with speed, certainty and transparency, access to public information and effectively monitoring of statutory compliance by the companies. Third, effective enforcement of Companies Act and other acts coming under the domain of Ministry of Corporate Affairs MCA for better corporate regulation and governance. Fourth, protection of investor and promotion of investor education and awareness for growth of corporate sector in the country. Fifth, to develop capacity building and secure policy advisory support through Indian Institute of Corporate Affairs IICA. Sixth, to promote competition. Seventh, to disseminate corporate sector data, official statistics as per National Data Sharing and Accessibility Policy NDSAP. Eighth, improving the functioning of official liquidators through application of e-governance. Ninth, developing and strengthening capabilities in Serious Fraud Investigation Office SFIO. Next, nature and scope. The Companies Act is the act of the central legislature. So, it applies to companies throughout India on a uniform basis, except that it is applicable to the states of Jammu and Kashmir, Goa, Daman and Diu and Sikkim subject to special provisions made and notifications issued by the central government. The provisions of this act are applicable to companies incorporated under this act or under any previous company law, insurance company except insofar as the said provisions are inconsistent with the provisions of the Insurance Act 1938 or the Insurance Regulatory and Development Authority Act 1999. Banking companies except insofar as the said provisions are inconsistent with the provisions of the Banking Regulation Act 1949. Companies engaged in the generation or supply of electricity except insofar as the said provisions are inconsistent with the provisions of the Electricity Act 2003. Any other company governed by any special act for the time being in force except insofar as the said provisions are inconsistent with the provisions of such special act, and such body corporate incorporated by any act for the time being in force, as the central government may by notification specify in this behalf subject to such exceptions, modifications or adaptation as may be specified in the notification. Next, machinery for administration. The central government has the overall responsibility for administration and enforcement of the Companies Act. The Ministry of Corporate Affairs MCA of the Government of India is the nodal agency authority given various powers under the Act. Most of the powers are vested to the authorities created under the Act. First, National Company Law Tribunal NCLT. The Companies Act 2013 provides for the constitution of the National Company Law Tribunal NCLT and lays down its composition and power. Chapter 27 sections 407 to 434 relate to the National Company Law Tribunal NCLT and the National Company Law Appellate Tribunal NCLAT. The implementation of the Amendment Act will mark the end of the High Court's jurisdiction over company matters. It will also abolish Company Law Board, CLB and BIFR. The NCLT will combine the work of all the company courts, the Company Law Board and BIFR, while NCLAT will substitute the appellate powers of the High Court. The NCLT and NCLAT have not yet been constituted. Therefore, the provisions relating to the NCLT are not applicable as of now. The tribunal shall consist of a president and such number of judicial and technical members not exceeding 62, as the central government deems fit. The qualifications for appointment of the president and members of the tribunal have been laid down by the Act. The president and every other member of the tribunal shall hold office for a term of 3 years from the date on which he enters upon his office, but shall be eligible for reappointment. The powers of the tribunal may be exercised by benches constituted by the president of the tribunal, out of which one shall be a judicial member and another shall be a technical member. The tribunal may, after giving the parties to any proceeding before it an opportunity of being heard, pass such orders thereon as it thinks fit. Any person aggrieved by an order or decision of the tribunal may prefer an appeal to the appellate tribunal. The tribunal and the appellate tribunal shall not be bound by the procedure laid down in the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice. The tribunal and the appellate tribunal shall have, for the purposes of discharging its function under this Act, the same powers as are vested in a civil court under the Code of Civil Procedure 1908 while trying a suit in respect of the matters as laid down by the Act. Any person aggrieved by any decision or order of the appellate tribunal may file an appeal to the Supreme Court within 60 days from the date of communication of the decision or order of the appellate tribunal to him on any question of law arising out of such decision or order. Second, regional directors. The 6 regional directors are in charge of the respective regions, each region comprising a number of states and union territories. They supervise the working of the offices of the registrars of companies and the official liquidators working in their regions. They also maintain liaison between the respective state governments and the central government in matters relating to the administration of the Companies Act 2013. Certain powers of the central government under the Companies Act have been delegated to the regional directors. Next, Registrar of Companies ROC. Registrar of Companies ROC appointed under the Companies Act 2013 covering various states and union territories are vested with the primary duty of registering companies floated in the respective states and the union territories and ensuring that such companies comply with statutory requirements under the Act. These offices function as registry of records relating to the companies registered with them, which are available for inspection by members of the public on payment of the prescribed fee. The central government exercises administrative control over these offices. Let us now learn about the meaning of company. Definition. Section 2, subsection 20 of the Companies Act defines a company as company means a company incorporated under this Act or under any previous company law. An existing company means a company formed and registered under any of the former Companies Act. Thus, a company formed and registered under the Companies Act 1956 or under any former Indian Companies Act is a company. Note, before passing of the Companies Act 2013, Indian Companies Act 1956, the Indian Companies Act 1850, the Indian Companies Act 1866, the Indian Companies Act 1882 and the Indian Companies Act 1913 were the enactments in India for registration and regulation of companies. These have since been repealed. Company and body corporate. Body corporate or corporate body refers to a body which is incorporated under a statute and has a perpetual succession with a common seal and is a legal entity separate from the members constituting it. The term body corporate is wider than the company and it includes companies registered under the Companies Act 2013 or any former Indian Companies Act. Foreign companies, corporations formed under special act of the Parliament or of state legislatures or of a foreign country. Public financial institutions as defined in section 2, subsection 72 of Companies Act 2013, nationalized banks, limited liability partnerships registered under the Limited Liability Partnership Act 2008. However, body corporate does not include a society registered under the Societies Registration Act 1860, a corporation sole, a cooperative society registered under any law relating to cooperative societies, and any other body not being a company as defined in the Companies Act, which the central government may by notification in the official gazette specify in this behalf. Note, company is a body corporate, but all body corporates are not companies. Next, company and corporation. Corporation means a body or institution having an independent legal entity and enjoying perpetual succession. It may be of two types. First, corporation sole, and second, corporation aggregate. Corporation sole refers to a single person which is constituted as a perpetual office in respect of some functions. Example, a public trustee, president, governor, minister, etc. It is not taken as a body corporate for purposes of this act, but it is still a legal person and can be a member of a company. Corporation aggregate means a group of individuals associated as one body having a perpetual succession and an independent legal entity. It may be a trading or a non-trading corporation. It includes chartered companies created by a royal charter, companies incorporated by special acts of parliament or state legislature, companies registered under the Companies Act, municipal corporations, district boards, universities, etc. Non-trading corporations. Let us now recapitulate what we have learned so far. Company is an association created by the law. In India, the Indian Companies Act 2013 contains the law relating to companies. The Act is a central legislature passed by the Parliament, and it received the assent of the President on the 29th August 2013. The Act, which is replacing the 5 decades old Companies Act 1956, shall be applicable from financial year 2014-2015. The objective of the Act is to provide simplified laws governing corporate sector and to facilitate effective compliances and enlighten regulatory regime. The central government has the overall responsibility for administration and enforcement of the Companies Act. The Ministry of Corporate Affairs (MCA) of the Government of India is the nodal agency authority given various powers under the Act. The Companies Act 2013 has introduced National Company Law Tribunal and the National Company Law Appellate Tribunal to replace the Company Law Board and Board for Industrial and Financial Reconstruction. Company means a company formed and registered under the Indian Companies Act 2013 or an existing company. An existing company means a company formed and registered under any of the former Companies Act. Company is a body corporate, but all body corporates are not companies. Thank you.